Welcome to EPG Pathshala. We are going to be discussing the course on social policy. The specific module under discussion now is Judicial Activism. My name is Sohini Sengupta and I am a faculty in the School of Social Work at the Tata Institute of Social Sciences, Mumbai. The concept of judicial activism is associated with the notion of public action, and it has grown rapidly in recent years and gained a huge legitimacy amongst people in India in the context of unrestrained and contradictory behavior of legislation and executive organs of the government. Within the framework of democratic ideals, there has to be a fundamental requirement for people's participation in order to influence government policies and programs. This is a prerequisite for good governance. Indian judiciary, by pioneering judicial activism in the context of our society, has played the role of an activist to promote interests of marginal sections. For the concern of social policy, the aspect of judicial activism that we will consider is the manner in which the Indian judiciary in the last few decades have translated a large number of social provisions into justiciable rights by creative interpretation of the Indian Constitution. Objectives of this module. In this module, the readers will understand the nature of judicial activism in India, the positive and negative trends in judicial activism, the significant contribution to the social sector through the active role of the judiciary in the context of India. The term judicial activism originates in the United States. Judicial activism in the middle of 20th century, in around the 1950s and 1960s, had a positive implication, as courts were essentially viewed as upholding democratic rights of people. This was also the time when the Supreme Court was concerned with upholding the rights of African Americans and other minorities in the United States. Several scholars have praised the efforts of judges in the protection of civil rights. Judicial activists were distinguished civil rights activists often, and many civil rights activists were actually Supreme Court lawyers and judges. More recently, people have been describing judicial activism more as a judge overstepping its authority, since democracies thrive on equal separation of power amongst judiciary, executive and legislature. Excessive activism on part of the judiciary is sometimes seen as stepping on to the rights of the other arms of the government. Judicial activism may be defined as an approach to the exercise of judicial review or a description of a particular judicial decision in which the judge is willing to decide on constitutional matters and to invalidate legislative or executive action. There are two components in this definition which are significant to our understanding of social policy. A, the fact that public activism essentially involves reinterpreting the Constitution to create a legal mandate for certain types of social and economic rights. And the second is sometimes when a government is not necessarily willing to address emergent social problems, then through public action, judiciary allows for the recognition of specific social problems even when the other arms of the government have failed to do so. Judges may be called activists for both permitting government action or because of restraining or forbidding government action. Judicial activism is considered controversial as courts, as the final interpreters of the Constitution, should not replace other branches of the government that are equally important. Judicial activism may result in conservative or progressive outcomes. Therefore, all forms of activism performed by the judiciary historically has not always been beneficial to social policy. Judiciary in the context of India. The democratic system of India rests on the separation of powers between legislature, executive and judiciary. The function of the legislature revolves around formulating laws. The executive consists of council of ministers, which looks after the administrative functions of the country within the confinements of the constitution. The role of the judiciary is essentially to mediate disputes, to check unrestrained behavior of the other two branches of the government, and to protect and safeguard the rights and liberties of the people. And this is essentially this last and the final role, the protection and the safeguarding of rights, is where the Indian judiciary has emerged as a forum of, as an activist branch of the government. Indian judicial system occupies a significant place as it reviews the validity of laws, their interpretation and implementation that is framed by the legislature. Its work includes settlement of mutual disputes and disputes that arise out of clashes between center and the states, and among the states also fall under the jurisdiction of the judiciary. The judiciary also protects the rights and liberties of citizens and tends to be regarded as an active agency which provides justice for everyone. Over a period of time, this justice creating role of the judiciary and its connection with protecting and safeguarding the civil and political liberties have led to a role whereby the Supreme Court has been a forum for listening to a large number of a diverse set of public grievances. As the society progresses and as economic development happens and large number of people become literate, there is a growing sense of not being necessarily dealt with fairly by the government. Large sections of the population may feel that their rights have been denied. Large sections of the population may have social and economic problems that are not being currently addressed by public policies. These disenfranchised and marginalized sections of the population have increasingly tried to access to the judiciary and tried to convey their sense of grievance to one of the highest authorities of the government. The recent failure of adequate enforcement of law leading to infringement of autonomy and safety of people has been one of the reasons why there has been growing number of public grievances and the requirement for an arena where public grievances against the government could be aired. The Indian judiciary performs its protective role to ensure positive, independent and fair justice. Commitment to social and economic transformation amidst changing economic and political scenario, coupled with growing incidence of poverty, has created tremendous pressure on the judiciary to ensure justice and to be able to listen to the range of grievances that are coming to its door. As both legislation and executives are commonly blamed for being indifferent to people's social problems or not being able to act or not being able to address their deprivations or engaging in corrupt practices, judiciary has been listening and responding to a large number of people and trying to address their concerns. One of the contributions of the Supreme Court in India, and from where it has been increasingly highlighted at its judicial activism, has been the interpretation of Article 21 of the Indian Constitution. The Supreme Court's interpretation of Article 21 has been crucial for the growth of judicial activism in the context of the Indian democracy. A large number of rights, such as the right to education, right to privacy, right to go abroad, right to legal aid, right to speedy justice, right against custodial violence, right to safe working conditions, medical aid for workers, right to pollution-free water and air, right to food, right to clothing, right to shelter, right of every child to full development, right to access to roads of prisoners, right to human and healthy environment, right to sustainable development. All of these concerns have been brought to the Supreme Court, and while these are not included in the fundamental rights, part 3 of the Indian Constitution, they have been made enforceable through wide and liberal interpretation of the Article 21 by the Supreme Court. Judicial activism promotes the goals of welfare state, and this is where comes the connection between judicial activism and social policy. With judicial activism, judiciary endorses a proactive approach where the court moves from its traditional functions of interpretation of law and settling of disputes between center and states and different arms of the government to protecting actively the rights and liberties of people. The activist role of judiciary not only defends the fundamental rights mentioned in the Part 3 of the Constitution, but also promotes socio-economic rights under the directive principles of state policy, envisaged in Part 4 of the Constitution, which are not justiciable. One of the ways in which public grievances has been one of the ways in which public grievances have been coming to the attention of the court, and how the court has been using its mandate to both interpret the law as well as in performing its protective function has been through the instrument of what is called the public interest litigation. Public interest litigation was introduced, which extended the functions of judiciary in public affairs. In the word of Justice Iyer, law is a social auditor, and only someone with public interest can ignite this. This is a very telling statement, because if you remember from our discussion on social audit and social accountability, one of the ways in which public programs and social programs can work effectively is by making governments more accountable to people and enabling people to participate in democracy in such a fashion that they can create accountability mechanisms. Public interest litigation is one of the tools which enable people to do this audit function in order to make laws which would otherwise be not used, work actively in protecting and safeguarding their key human rights. Justice Bhagwati, on the other hand, viewed that courts should adopt new techniques and approaches to provide free legal aid to those sections of society who are deprived of basic human rights. Therefore, one can see two different ideas about judicial activism, and which can contribute towards widening of the understanding of judicial activism, and not just a negative development of judiciaries overstepping on the roles of the other branches of government, but also how judiciary can perform a social audit function, and a judiciary that can also enable large sections of marginalized population through the provision of free legal aid and other forms of assistance to bring their social concerns to the court. Highlighting social concerns. In the 1980s, judicial activism appeared in the form of writ petition by two academics who described the brutal conditions of imprisonment in the Agra Protective Home for Women. Degrading and callous conditions of protective homes violated Article 21 of the Constitution, and inmates, due to their lower financial status, who could not seek judicial redress. Conditions of laborers at construction sites, the eviction of pavement dwellers, custodial violence meted out to women prisoners, all of these were communicated to the court through letters, since the petitioners did not necessarily have the resources to seek judicial redress. The court treated the letter as writ petition, and with this, the public interest litigation was well and truly in place and performed its job of creating the concern of judiciary and extending it towards protection of the rights of marginalized and disadvantaged sections of society, who've increasingly found easier and easier to access the court. In recent years, a new type of public cause litigation has come into the forefront, where the court's intervention is not only limited to looking into the plights of the disadvantaged, but also correcting the activities of government bodies. This could be seen as the contribution of judiciary towards good governance in general. The Supreme Court, for example, has directed numerous interventions for day-to-day public affairs, such as control over automobile emissions, air and noise and traffic pollution, It has given orders for parking charges, disposal of garbage, control of traffic in New Delhi, made compulsory the wearing of seat belts, ordered measures to prevent accidents at unmanned railway crossings, prevented ragging of college freshmen, collection and storage of blood banks have been regulated, for the control of loudspeakers and banning of crackers, banning of pasting of black film on automobile windows, prohibition of tourists in tiger reserves and so on, in the name of better and good governance. As a result of the activist role of judiciary, the Supreme Court has contributed tremendously in the formulation of progressive legislations like right to food, right to education, and right to information. Social activism in India has acquired a new dimension because of judicial activism. Supreme Court's involvement in the 2G spectrum and coal block allocation scam, instruction to states to provide midday meal to school children under landmark National Food Security Act are some of the instances where Indian judiciary has come out of its traditional role of interpreting laws and taken a firm stand against social injustice. If we look at social policies and development in the current context, it is increasingly framed in the language of human rights. In the past, development was focused on social welfare and growth. Human rights involve, however, establishing a universally accepted legal regime that conceptualizes right in terms of duty bearers and right holders. Judicial activism helps governments to remember, it reminds governments of its duties, and it allows for the respect of the rights that citizens actually hold and the rights that citizens can always demand that their governments respect. Rights approach contributes to the development agenda in a number of ways. It adds legal tools and institutions such as the judiciary and processes such as litigation as means to secure development. It shifts emphasis towards those who have been excluded from gaining development benefits. It stresses the importance of voice, information, and integration of civil and political rights into development processes. Judicial activism, in fact, has emerged in India with the judiciary slowly expanding its role in order to fit into this entire rights-based approach to development. So the judicial activism, in fact, can be considered to be an aspect of the nature of development and how development has emerged. Development is increasingly framed in the language of human rights, and that's where judicial activism actually stands. So in the end, what one can see is rights-based approach contributes to empowerment of citizens to demand the delivery of rights and services that they're entitled to. It develops the capacity of states to fulfill the obligation to protect, respect, and promote the rights of their citizens. It strengthens participatory grassroots processes to empower vulnerable groups. When people realize that their social concerns or their social problems are not being met, and the fact that they have a tool of redressal by using public interest litigation, by appealing to the judiciary, by igniting the activist role of the judiciary, all of this ensures that the agenda of rights-based development and the goal of social empowerment actually is accomplished. And with this, we come to an end on the module on judicial activism. To summarize briefly, public action through judicial activism has created a debate in the Indian society. The concept has attracted both admiration and opposition. The admirers regard judicial activism as necessary since democratic ideals of Indian society are reinforced through judicial activism. And the fact that people's lost faith in judiciary, which was earlier only limited to the rich and elites, has now been re-established once people have realized that their grievances would be heard and action would be taken, and different other branches of government will be asked and directed to fulfill their duties and obligations. Critics of judicial activism believe that judicial activism grants unwarranted authority to judges, which in turn disturbs the balance of power between legislation, executive and judiciary, which is essential to Indian political structure based on the separation of powers. Irrespective of this particular controversy about judicial activism, what one can take away from this debate is that in recent times, the manner of activism that has happened through the Indian judiciary's work on social and economic rights has contributed greatly towards towards the achievement of citizenship rights, as it has been envisaged in the broader normative goals of social policy. So, in this module, we learnt about the meaning and definition of judicial activism. We tried to understand the origin of judicial activism in the context of the United States. We saw how the meaning of judicial activism moved from that of a progressive deliverer of justice in the context of United States to a more conservative body, which is apparently overstepping its role and outside its mandate. Judicial activism in the context of India has meant different things, because in recent times it has led to the use of instruments such as public interest litigation by people to address a variety of social and economic concerns of people. This addressing of the variety of social and economic concerns have led to concrete measures such as the emergence of social legislations like right to food, right to shelter, right to education, right to information, and all of these social and economic rights have empowered citizens, and not only because they have felt that their concerns have been met, but also because it has restored their faith in the democracy and the fact that a democracy that respects citizens' participation, that is committed towards fulfilling the economic and social rights of people. Broadly, judicial activism in India has proceeded through the creative interpretation of Article 21 of the Indian Constitution, whereby a large number of social and economic goals have been interpreted to be social and economic rights. Judicial activism also fits very neatly into the universal global agenda of rights-based development, which tends to see social economic development not simply as benefits that governments give to their citizens, but as rights and entitlements, and the fact that governments have a duty and an obligation towards their citizens to fulfill these rights. The Indian Supreme Court, therefore, has been following these broader global changes which have emerged to address the greatly increased prosperity of nations simultaneously with divisiveness and high levels of poverty and inequality in some society. With this, we come to an end of this module. Thank you.